ladies and gentlemen. At this time, I would like to ask all in the council chambers to turn off or at least set their cell phones to vibrate. Today is April 4th. April 4th. And the public hearing of the Stratford Zoning Board of Appeals will come to order to hear those petitions advertised for this session. For those of you that are not familiar with our process, each petitioner or their designated representative will present their case to the board. When they have concluded, the board members will then have an opportunity to ask any questions they may have. I will then ask if there's anyone who wishes to speak in favor of or in opposition of the petition. We will ask all petitioners to speak clearly and directly into the mic. After all petitions have been heard, we will then recess to our administrative session. Interested parties are welcome to stay. However, only board members and staff will be allowed to speak at that time. Please be advised that clapping, shouting as a way of expressing opinions on the applications is not allowed or tolerated. Okay, thank you very much. Petition number 1. Ms. Young, would you like to take it off the board?
I'm going to be abstaining from the first 2 applications. Okay. Would you like me to remove myself to the audience, or shall I stay seated?
No, stay seated.
Okay.
Tom Gregg is sitting in for Mary Young. Tom's sitting there with all his friends. Would you like to take petition number 1 off the table?
I would, Mr. Chairman. Petition number 1, 446 Riverdale Drive. Petition of Edward Damas and Gail Stanger seeking waiver of allowable lot coverage to construct an attached garage in an RS3 district. The hardship: original garage is small by today's standards.
Would the petitioner please come up?
Good evening, members of the board. Good evening, members of the board. Thank you for listening to our petition this evening. Gail and I live at 446 Riverdale, and we are asking the board to consider a variance request of 70 square feet over the RS3 maximum allowable limit of 20%. That would bring the percentage to 20.7%. The request for the additional size is based more so, if we peel the onion back another layer, is more for safety purposes because of our elderly parents and their need to travel in a car with walkers, canes, additional equipment for them.
Excuse me, I have one
Yes,
question.
yes.
Do you have your mailers?
Yes, I do, sir.
Okay, please.
Yes,
give
I
it
do.
To the young lady over there.
Mary?
Okay.
As I was saying, the size is being requested for safety purposes to allow our elderly parents ingress and egress out of vehicles because they have walkers in canes. We have grandchildren. We'd like to be able to safely get them out of a baby seat in the car. You're also asking for the extra space because we need it for equipment that we can't leave in the backyard with the winds and the weather. We have nowhere to put it without it blowing around and it potentially impacting some other things in the neighborhood, people, and so on.
Is that it? Would anybody have any questions? No. Mr. Hoydick?
I just have a question on the driveway.
Yes, sir.
How much impervious area is the driveway going to take up? Do you have any idea?
There is a mistake on the plot plan. The horseshoe driveway is not the one that's going to be put in. It's going to be just like the driveway that we have right now.
It's going to be a regular driveway?
It's going to be a regular paved asphalt driveway just going from the street into the garage.
To the garage, okay.
There was a mistake made on the plot plan. We apologize for the incorrect drawing.
Okay.
It's got,
Okay, great, thank you.
if you look at some of the elevation drawings, you will see a frontal view that has the proper driveway configuration.
Okay.
And And if you'd like another copy, I certainly have an extra copy if you'd like to see that.
Okay. Any more questions?
I have a question.
Mr. Krieger?
This here is going to be a one-car garage?
Two-car garage.
Two-car? Do you know the size of it, approximately?
It's
22 by 27?
27 long, 22 wide.
Okay. Would you know the height?
9?
it's a 9-foot high garage.
Well, that might be the door. Excuse me, that might be the door. I think the garage is higher than 9 feet.
Oh, okay, you're talking about the total building on that side? You remember what the,
The second story? I'm sorry, I can't hear you.
I did ask for the height of the garage, but my drawing isn't clear here. This is going to be built under a building, a room's going to be built above it?
A room will be built above.
Okay,
That will only come out 18 feet, not the full 22.
okay. Thank you.
Any more questions? Mr. Hoyt?
Yeah, just one more question. You said that you have your elderly parents.
yes,
Is there an in-law apartment in this,
no.
Not an in-law apartment, we have a downstairs guest room.
but they live in the house with you full-time?
No, from time to time they'll be visiting.
Okay, okay, all right. But they visit quite often, is that?
Yes.
And the plan is for them to enter through the garage, is that what it is?
Yes.
To make it easier? Yeah, but it would make them easier for them to enter and exit the house, to pull in the garage and go in through the garage?
Correct.
Okay,
Correct.
thank you.
Any more questions? Paul? Anybody? Okay, thank you very much.
Thank you, members of the board.
Would anybody like to speak in favor of this petition? Would anybody like to speak against the petition? Hearing none, motion to close. Mr. Hoydick, second by Mr. DeCilio. Thank you very much. Okay, petition number 2. Mr. DeCilio, can you take that off? I thought you were sending them out. Wait,
I'll just tell.
Okay.
466 Riverdale Drive, petition of Joseph Garrix seeking waivers of the front setback and allowable lot coverage to permit renovations in an RS3 district. Stating the hardship is the existing house location does not permit compliant entryway.
Okay, please state your name.
I'm Joseph Garris. This is my wife, Susan. By the way, I should have said we're in favor of the preceding petition.
That's good. Do you have your mailers?
Yes.
Okay, proceed.
We have a request to build a deck on the rear of the house. As it's designed on the drawings that you have, I think it's the best aesthetic option. The deck is oversized for the lot coverage, but a deck of that size would permit us to have a small seating area, a small dining area, and a small cooking area. If we were to comply with the lot coverage requirement, the deck would have to shrink to 83 square feet. That would be only 8 by 10, and we'd have to relocate 2 of those areas, either the cooking, of the cooking, seating, and dining, down to a patio on the ground. And actually, I think that would probably be a little bit more of a problem as far as runoff goes. Regarding the front entryway, we're reconsidering that. We've run into some engineering concerns about the front entryway, and we are considering now changing that from an entryway to an open portico, which would have 2 columns and a gable entry. We designed that again for aesthetic reasons. Just the plain front of the house with a 2-story house, I think a portico or entryway would be a much more attractive addition to the neighborhood. We chose the size based on the home that we have now. This is somewhat smaller than the entryway to our current home. If we're denied the setback variance, we could shrink it to comply, but we think it would not be as good a look for the neighborhood if we had to shrink it by 11 inches in depth. So those are the two reasons for our petition. I think that in reviewing what's happened in the past, our requests are consistent with other things that have happened in the neighborhood. There have been a number of front setbacks allowed and increases in lot coverage, in some cases to permit a deck also. In one case, right next door to me, the lot coverage is 25%, and it's probably one of the most beautiful homes on the street. So I think, I hope you will consider our application favorably.
Thank you. Any questions? Mr. DeCilio? None? None? Okay, hearing no questions. Thank you very much. Would anybody like to speak in favor of this petition? Okay. If you would like to speak in favor, come up, please. Didn't say. Okay. Okay, would anybody like to speak against the petition? Hearing none, motion to close. Now, one by Mr. Tavares and Mr. DeCilio. Okay, moving right along. Petition number 3. Would you like to take that off the table?
My pleasure. 1745 Cut Spring Road, petition of MFD LLC, seeking a waiver of the allowable front setback to legalize work done to a single-family dwelling in an RS3 district. The hardship is topography conditions.
Good evening, members of the board. Thank you for having me here. My name is Joseph Giavold. I reside at 17 Colonial Drive in Monroe, Connecticut, and I'm here as a manager of MFD LLC, which means my 4 daughters. This is actually my 4 daughters' investment in real estate. They purchased this house back in May of this past year. It's a house that was built about three plus years ago, and it went into foreclosure by the owners. They held a mortgage for the buyer that was supposed to pay for the lot in the house and never paid, so it became a complicated foreclosure. They foreclosed it sometime last year, I believe in March or April. We came in and purchased the property. The house was built already. The existing house was completed. The only thing that was left to do was the driveway, landscaping, hardwood floors, kitchen cabinets, repainting, and putting kitchen appliances in. I think everybody's got a package on the house. Basically, it's a 2-story. Actually, if you count the basement.
Questions? You have your mailers?
Yes, I have the mailers. You want the original mailers or the copies?
Copies be fine, right?
Sorry about that. There should be there's a survey and everybody's set of copies there. If you open the survey up. The as-built survey was just completed by James Dennison from Stratford. And as you look at the front setback, the front setback is 25 feet. The existing setback of the house is 27 feet 2 inches, and the porch is 23 feet. There'll be no problem with the porch. It's exactly built as it was supposed to be built. But what they did is they put a roof over the porch. It's an open porch with 2 posts on it and a portico, open portico, coming down to the steps. If you look at the picture, there's a picture in there that shows the side elevation with all the steps coming down. So basically that cover, that roof is what goes into the setback. So that's what I'm seeking here is a variance on that roof, the open roof, which actually is very attractive and kind of goes with the house very well, so it doesn't just look like a box. So it creates a nice gable effect. It's a very nice house, nicely landscaped, and like I said, it's existed for over 3 years in its present state. We have a contract on the house, and the only contingency we're waiting for is we got this as-built survey. We're waiting for a certificate of occupancy, which we can't get granted until we clarify the 2-foot setback on the coverage on the roof, on the porch. We didn't build it, we didn't put it up. We unfortunately inherited it. And, looking at the surveys that were approved, everything looks fine because the existing plans that were approved did show the steps in the porch, but it didn't show the roof because that's what created the problem. Otherwise, we'd be fine. So I just have a letter here just from my attorney, Robert Gospin, stating that the house is under contract. We purchased MFD. My 4 daughters purchased the house. They didn't build it, and they're just innocent. The result of the survey, we found out that we had to go for a variance. So we're just trying to ask this board in their leniency to hopefully be able to approve the 2-foot setback so we can go along and get our certificate of occupancy so we could just sell the house on 1745 Cut Spring Road. I think everything's in there. There's a side elevation that shows it's a pretty steep grade. The topography on this property is very, very steep. You can see a large number of steps. Very narrow property. It's very wide, and they couldn't have really set the house back anymore because there's really not much of a backyard. And I could see why this lot was probably the last, not even a lot, but got approved at some point by somebody, and it was the last lot built on that area. If you look at, there's only 3 houses, the house to the left and another house to the left, that have this steep elevation. But I think overall, looking at the house, you'll see it's an attractive colonial house. You'll see the open, it's not an enclosed porch. The building is exactly like it's supposed to be. The steps are like they're supposed to be. We're only dealing with the small roof of covering, which I think really enhances the house and makes it, in a beautiful neighborhood, makes it a nice house. It's right next to Roosevelt Forest. So hopefully the board will grant this the variance.
Okay, thank you. Any questions? Mr. Tavares?
Thank you, Mr. Chairman. The house is currently vacant?
Yes.
It's unoccupied?
Yes.
And with that upgrade there, I take it that's going to be graded when the steps come out?
No, the steps, the house is all 100%, it's done, 100% done. Everything is complete. The grading, all the grass has been planted, the landscaping has been done. It's all completed now. That was before it was completed.
Okay, thank you.
It's very nicely landscaped. If you go by there in the front of the house, you can see it, and a very nice driveway.
Mr. Hoyt?
Yeah, after looking at the house and the parcel, I can understand why the original contractor couldn't put the house any further back. There's all ledge, and it's in a really precarious position, which makes me believe that had he been able to push the house back another 5 feet, you wouldn't have this issue right now in terms of your front setback, which kind of leads me into the area of a hardship. Even though you didn't build a house, there had to be some kind of hardship imposed on this guy to put the house where it was because of the topography of the yard. That's all that's my observation after, looking at the house itself. So, but that's all I want to say.
Thank you very much. I makes a good point. Thank you.
Ms. Young?
If I can ask our Planning and Zoning Administrator, if I heard the gentleman at the podium correctly, but for the roof on top of the porch, he wouldn't be here. Is that an accurate assessment in your opinion?
Yes.
So a fix to relieve him from being here would be to remove the roof?
Well, there may be some building code issues that are involved in that. I'm not sure if the steps have to be covered by, in order to meet building code.
I have a non-conforming set of steps in my front yard. If that's the case, I don't know.
Yeah.
Sir, do you know the answer to that question?
There would be a life safety issue on the front steps because of the steepness. And the guy that built it used composite material to put up the deck and the steps, and it's very slippery if you guys have ever walked on. In fact, the zoning guy, John, actually said, my God, it's so slippery. I said, yes. The problem is you don't want to leave an open porch on top, because when somebody comes out of the house, this is actually a single woman that's buying the house, so if she came out, could you imagine her coming out with no coverage? It'd be solid ice. She'd be flying off the porch. Just gives her a chance. I'm an insurance person. From a loss control standpoint, it's a very good feature to have on this house. So if somebody was to slip, it could prevent them. I mean, they'd be dead if they fell down all those steps. So I think it's a great feature to have on this house, and I'm sure, I don't know the building code, but I know from a life safety standpoint, it makes a lot of sense.
Follow-up question. Are you in possession of a copy of the March 17th comments prepared by our Planning and Zoning Administrator regarding this application? I'm referring to a document that's in our file. I'm wondering if you've seen it before. I'm handing it to you.
Which one? I don't know. Yes, I did get a letter like that. I did see that.
I just wanted to ask if you could get on the record a response to some of the questions raised by Mr. Hibansky in this narrative, where he asks questions as a follow-up to Mr. Hoydick. What is the hardship, if you could articulate that, and did you explore any other alternatives than the one that brings you here tonight?
I think the real hardship is, was brought up by one of the fellow commissioners, is in reviewing, and I've built in the past, because the lot is so narrow and it's all ledge and so steep. If you look at the inside steps, or right inside, when you walk in the front door, there's a small walkway, then there's steps going down. So if you can't go any further back, and if you put it any more inside, you wouldn't be able to do steps going down to the basement. It would be a real serious problem the way it's designed. So based on the topography and the steepness and the lack of width, that's the hardship that was created, I believe, for the previous builder, and that's what I'm relying on. And the fact that I'm also the innocent party representing my daughters that had no knowledge of the roof, because everything looked fine. So we're just trying to clarify something that I think certainly enhances the neighborhood. I don't think it adversely affects anybody. I don't think it's against public policy. And I think this is one of the points that I think for zoning variances, that's why we have a zoning board of appeals. So if we do have a problem that's honest and legitimate, that we could correct it. It gives us an avenue to try to correct the problem. And that's, I was trying to explain to Jay, Mr. Zoning Commissioner. Jay.
One last question, if I may. It sounds like you know how we operate very well. Thank you.
Thank you.
So if topography is your hardship, would you have any objection as a condition of approval if you were granted a variance tonight to add the topography to your plan so that the record demonstrates why this board granted your variance? I'm not seeing any contours or elevations on the survey where you're citing topography as your hardship.
Well, the topography, the picture shows the specific topography and the drawing.
The drawing is what I'm referring to. I'm not seeing the contours, elevations, topography. I'm not seeing that on the survey. I see it in the photo.
Right.
That's not the same thing as seeing it on the survey. My question again is, would you have any objection as a condition of approval to modifying the survey to show the topography, to demonstrate a record of why we might have granted this variance?
I do have the flood elevation, so I would have all the elevations that were prepared by James Dennison after to show all the elevations of everything at the house. I have a flood elevations on
So
everything.
is that a yes to my question?
Is that what it would?
I'm looking for, if you're so inclined, I don't want to put words in your mouth, would you be willing to add topography?
Yes,
to
I
the
would if I had to.
as-built
Yes, if that's what the board felt that I needed to add, I would add it. Hopefully what I have is adequate.
This one member would feel more comfortable if we were to grant this variance, citing topography as our rationale if we actually had topography on the record.
Right.
So thank you for your questions and answers.
Thank you very much.
Any other questions? Mr. DeCilio.
Mr. Vole, thank you. I did some research on this property. Are you aware of the history of how this lot was created by the previous owner?
No, Dave.
So you're not aware that this was divided off another lot and there was a joint venture to create this spec house that you're seeking a waiver on?
I believe that's the house in the back, the same people that own this lot,
Correct.
the family.
Yes.
I believe that's who financed it with that lot, and that's the people that got hurt by the process. Whoever the builder was had a tough reputation. I don't know who he is, but I guess that's how he got it approved, I believe. You know, with a subdivision.
And do you know if the house that was built is the same with this portico and roof as the plans that were submitted to the building department? Or did the builder just take it upon himself to do whatever he wanted to do?
I believe everything looks the same, but what I believe, looking at the drawings that I looked at, it looks like he would have ended it even. In other words, if you look at that picture, my picture, if you look at the end of the steps, I believe the way he drew it, he was evening it with the house. He wasn't bringing it out to cover the steps that extra 2 feet or 3 feet,
Right.
because the steps are 3 feet.
The reason is, and the reason I'm bringing this up is, it appears to me, and the commission will render their decision later, that this lot was chopped off. When I drove by it, it was a tough lot to begin with.
Very tough
It was a
lot.
tough lot. So he grabbed a lot. And then the house, I'm looking at the A2 survey, and you know I'm in the real estate business as a professional. This is an unusual shaped house. It's like a square instead of a rectangle. So they intentionally packed 11 pounds of house into a 10-pound bag here, is what,
I couldn't
not
put it
you,
better
but the
than that.
pre-
You're exactly
So now
right.
you're here before us because they built a house that didn't meet code. I understand you were, or whoever you represent, were simply investors financing this deal, and you inherited this back as a deal gone south or gone bad.
Yes.
But again, to Ms. Young's question, I don't understand this hardship. It seems absolutely self-imposed within the last several years, because I did all my research. And I can empathize with you. I guess there's no question in there. It's more pontificating in statement, but I have a grave concern with this, just so you know.
Okay, any more questions? Nope. Thank you very much.
Thank you, Reverend.
Would anybody like to speak in favor of this petition? Anybody like to speak against the petition? Hearing none, we need a motion to close. Mr. Hoydick, Ms. Young, and petition number 4.
Petition number 4, Lot 700, Margarita Lawn, petition of Artemo Alvarez seeking waivers of the minimum lot width to create a new building lot for a single-family dwelling in an RS-4 district. Hardship, pre-existing non-conforming lot and structure that predates zoning.
Please state your name.
Good evening, Mr. Chairman, members of the board, Madam Secretary, Mr. Urbanski, Attorney Florek. My name is Robert Rosati. I'm an attorney here in Stratford with my father, Thomas Rosati. Our office is at 3241 Main Street. I'm also a resident of Stratford. I'm here tonight representing Artemio Alvarez, the record owner of Lot 700 Margarita Lawn. It's a vacant, pre-existing, non-conforming lot, 50 feet wide by 150 feet deep, which has existed since 1913. We are here seeking one waiver of minimum lot width of Section 4.2 of 60 feet down to 50 feet to build a single-family home on Lot 700, which is in an RS4 district. The house will fit in harmony with the lordship area, and the house and lot will satisfy all setback, lot area, and all the other requirements of the RS4 district. I'd like to submit a copy of a map entitled Lordship Manor as an exhibit. It shows Lot 700 on that map. That lot has existed as a 50 by 150-foot lot at least since 1913. That's map number 56, recorded in the town clerk's office, dated again 1913. It's recorded April 23rd, 1914. It was accepted by the town selectmen April 23rd, 1914. I'd also like to submit copies of maps 57, 58, and 60 from the town clerk's office. Those are all dated 1911, and it shows the entire Lordship Manor area. It's approximately 1,000 lots when you put all these maps together, laid out mostly as 50 by 150-foot lots, just like our Lot 700. And remember, our Lot 700, most of this area is in an RS4 zone. I'd also like to submit a highlighted copy of Assessor's Map 50.02. That shows Lot 700 and the surrounding area. There are many similar-sized lots with single-family homes. I've highlighted 143 of them. Some of them even have less frontage and lot area than Lot 700. In looking at the assessor's map, many of the homes were built on 50 by 150-foot lots. And yes, many were built on combined lots. But Lot 700 has never been combined with another lot. And I submit a copy of the aerial map from the assessor's website, which shows Lot 700 highlighted in red. It's the only remaining separate lot with nothing built on it in the area. I also like to submit copies of the street list from the assessor's website for Margarita, Victoria Lawn, Maple, and Lordship Road. It shows that the only separate vacant parcel without a street number is Lot 700 Margarita Lawn. I'd like to submit a copy of the Engineer Department's sewer map, which shows a separate sewer connection for Lot 700. And I submit a separate tax bill for Lot 700. There is no merger here. Lot 700 remains open, distinct, and separate, like many of the other 50-foot original lots that were built upon. This is not a merger situation, as you can see from all the maps presented. There is no intent or physical act of the owner to abandon the separate status of Lot 700. The house, as you can see from the aerial and the assessor's map, is not built over the line. Again, yes, there are combined parcels on that assessor's map. There are houses built over property lines. But the house here next door is not built over the line. There's no combined legal description with any other lot. There's no map combining this lot with any other lot. Again, just because other houses in the area were built on combined lots doesn't, maybe that's a merger situation, but this is not a merger situation. And again, I think that aerial map speaks for itself. It's the only lot in the area with nothing on it, and it's important to note that we have no merger regulation in Stratford. I'd also like to submit a copy of the original deed for this Lot 700. It's from the Lordship Park Association, dated May 29, 1914. That's volume 76, page 74. And I've highlighted, it's a deed for two separate 50 by 100-foot lots, Lot 700 and Lot 701, and it states that not more than 2 dwelling houses shall be erected. I also submit a copy of a separate deed for the house next door, along with 7 other lots, a total of 8 50 by 150-foot lots, This deed, and I've highlighted, states not more than 8 dwellings shall be erected. It's lots 692 through 699. And that's in volume 76, page 335. If you go to our town clerk's office downstairs and open up volume 76 from 1914, it contains close to 1,000 deeds from Lordship Park Association. And in every one of those deeds, whenever a 50 by 150-foot lot was conveyed, it stated it was for 1 dwelling to be erected, similar to those deeds. If 2 lots were conveyed, 2 dwellings. If 3 lots, 3 dwellings. So the intent clearly was that for each and every one of these 50 by 100-foot lots, like our lot 700, for each one you can build 1 house. 1 house equaled 1 dwelling. That's the way they set this out in approximately 1911 to 1913. That was clearly the intent of Lordship Park in laying out these lots, that a house could be built on each and every one of these lots. Now, again, along the years, some people, before and after zoning, combined lots and portioned lots and committed them to developing houses on them. That's what this assessor map shows, along with the 50 by 150-foot lots, 143 of them, which the assessor's map shows. But that is not the case here. Lot 700 is still sitting there all alone all these years with nothing on it. It's a separate and distinct 50 by 100-foot building lot that Lordship Park Association intended to have a house on, and owners for over 100 years intended to keep separate and have kept separate so one day a house could be built on it. Again, if you look at that aerial map that I submitted, it's separate. There's nothing on it. There's houses and house numbers on every other parcel on that map, and you have to keep in mind this is an RS4 zone. Now, to carry out the intent of Lordship Park and the owners for over 100 years to build a dwelling now on lot 700, we need the requested variance of lot width. And to ask for the variance, we must state the hardship. Lot 700 is a pre-existing, non-conforming separate lot shown on a recorded map prior to zoning. It's never been merged with another lot, but it's not protected by our statutes, section 8-26A regarding changes to subdivision regulations, because that's a lot and a map that predates zoning, and it's not protected as a non-conforming use because it's not yet been committed to development like the other lots in the area. Therefore, we need the requested variance. Without the requested variance, a single-family home can't be built on this existing 50 by 100-foot lot, even though other single-family homes in the area, in this development, have been built on 50 by 150-foot lots. And that's, again, the Lordship Manor maps. The applicant is specifically hardship now by the enactment of the current zoning regulations, which require 60 feet instead of 50 feet. Regulations that were enacted after the lots were laid out, after the area was already developed. The applicant is hardship by the strict application of zoning regulations regarding lot width on this pre-existing lot 700, and this hardship is specific now to this unusual sized 50 by 100-foot lot because it's the only lot left in the area. Everything else has been committed to development. So this board is authorized to grant this one variance because it will not substantially affect the comprehensive plan in the RS4 zone, and strictly adhering to the lot width zoning regulation will cause unusual hardship to the owner of lot 700, which is not necessary for carrying out the purpose of zoning in the RS4 district. This matter is similar to the case Johnson versus Board of Zoning Appeals of the Town of Stratford, and the cases that were cited in that case, and I have a copy of that. The case that Attorney John Florick is very proud of, and I've discussed it many times with him. In that situation, it was decided that there was a separate 50 by 100-foot lot created prior to the 60-foot zoning requirement of our zoning regulations. And in that case, the owner had a right to seek a variance due to the hardship of the enactment of the zoning regulations that came along after these 50 by 100-foot lots were created. There's a misconception that this part of lordship is maybe not an RS4 zone or not a 50-foot area. It's very similar to the situation in Paradise Green, where townwide in an RS4 zone, over the years, hundreds of similar variances have been granted in this exact situation. Nearby, I believe 55 Cherry Street, 115 Washington Parkway, and 57 Cedar Street have recently received similar variances. Now, I think with those comments, I've addressed most of Mr. Urbanski's staff comments, but he does have one regarding drainage, and in response to that, we have to deal with the engineering department. And the engineering department is tougher than all the departments in this town hall most of the time. So we have to satisfy their stringent conditions and requirements and their inspections when we're trying to go forward and get a building permit and getting a CO if this is granted tonight. So we're not going to create a drainage problem if we're under the watchful eye of the engineering department and the inspections from all the departments. Now, regarding any neighbors' concerns, specifically the neighbor at 150 Margarita Lawn, we want to do everything possible to address the concerns of that neighbor. And what we are willing to do is agree to certain conditions if this is approved. On that side of the property, we can locate the garage. We can flip the plan over and locate the garage, stay within the 10 feet setback, even though we can go 5 feet because it's not living space. We're not going to do that. We can have dead space over there that's 10 feet away, and we can make that a condition. We can also make a condition that no windows will be put up on that side of the house. We will meet with that owner and provide any screening along the boundary line that might satisfy that owner. And again, we can put that in as a condition. His concerns, if we are able to go forward with this project, are a huge priority. We feel that we are adding a home that will be in harmony with the lordship area. It will improve property values, and it will not create any hazards. For all the foregoing reasons, we urge you to grant this variance tonight.
Any questions? Ms. Young.
Attorney Rosati, this application was submitted, I assume, probably more than a month ago.
Yes.
I'm wondering why only tonight are you providing a single copy of multiple exhibits, none of which any of us have seen.
Because that's what I've done for 30 years, and these are exhibits to submit tonight, not anything that's required at the time of application.
Thank you for your answer. I guess the point I was making in asking my question is I may be persuaded that some of the exhibits you provided tonight might help me understand better your position,
Yeah.
and I feel deprived not having had the
And it took
benefit of
me-
seeing them beforehand.
It took me 8 hours yesterday in the town clerk's office to find most
I
of them.
can believe that. I will have a few more questions, but I am inclined at this moment, without hearing more from my fellow members, to want to leave this hearing open so I do have the benefit of reviewing the materials you submitted tonight. To the point, if you spent a whole working day gathering them, I would at least want to give credit to having reviewed them before rendering a decision. But based upon what I've heard you describe tonight, I guess I have a couple of more questions, if I may. I understood you to say there is no merger provision in play. I heard you say that this is a separate legal lot, yet you can't develop it without the variance being granted as you have requested. Did I hear that correctly?
I didn't say it was a separate legal lot. I said it was a separate lot. It's been kept a separate lot and we don't have a merger doctrine. It's a pre-existing lot from the 1900s.
Was one of the exhibits you provided tonight showing that the creation of this lot was shown on a recorded yet not approved subdivision map?
It was approved by the selectmen at the time. It was impossible to get approved by zoning because zoning didn't exist. And I think, it follows the case law. And I think it's important that we don't have a merger doctrine. And I do know in Westport, and I think 6.3, you do have a merger doctrine.
But I realize I'm not in Westport anymore. But thank you. I guess
But I know where your experience is, though. Yeah.
Thank you. I guess what I'm wondering, and you are the attorney at the podium, so again, if I could get some education, I thought that your client would have the benefit of a recorded map being on file on the land records, even if they didn't have an approved map following the enactment of the subdivision regulations. And so I'm wondering, really, do you need to be here? And I guess maybe Attorney Flora can help me if I'm needing an education as to if you have an approved map or approved or recorded map on file, does that not give you legitimacy, if you will?
I would love to have that opinion. I've tried to get everybody in this town for 30 years to have that opinion, but a lot of discussion, a lot of meetings. I think what it comes down to is, at the time, the selectmen did not have the powers to act as zoning officials. There's some special acts back then that I've presented to Attorney Florick that I felt maybe was the equivalent of zoning powers, but ultimately the town attorney has always come back and said, nice try, but that's not the case, and they've relied upon the Johnson case. That being said, the remedy, because of the enactment of the zoning regulations that came along after the selectmen stamped those maps and allowed them to be put on the land records, the only remedy that a property owner has in a situation like this is to come before this board and prove the hardship, which we have, the enactment, and to get the variance granted and proceed with construction.
So again, not being an attorney, I was under the impression, I'll say, that if you had a recorded map, whether or not it was approved, but it was recorded on the land records, that gave you status prior to the enactment of any subdivision regulations of having a separate legal lot for which you could build without the necessity of a variance. But that's a legal question that perhaps has already been vetted. But again, I'm looking at Mr. Florick to see if he can help me.
I'm mostly in agreement with Attorney Rosati, and don't forget, I see Attorney Proto lurking around the council chambers here, so I'm sure he'll have an opinion on that as well. But what Attorney Rosati is saying is essentially correct, is that the selectmen in 1921 accepted the map, but at that time they weren't granted powers equivalent of a planning commission, so that acceptance of the map didn't shield that parcel from future changes in the zoning regulations. That is why they are here seeking a variance.
But it was recorded, that map.
It was recorded, but they didn't have the power of a planning commission.
But if now if this...
I understand the distinction you're making. And when were the subdivision regulations enacted in Stratford? Subsequent?
1927?
Yes.
Something like that.
This argument might go differently if it were in Westport, but I'm taking my lead from you knowing I'm in Stratford tonight.
That's right. So far, we're all on the same page, though.
And
He wouldn't be here if I were in Westport.
I got to find some projects in Westport.
So one more question, if I may. I heard you describe that you are sensitive to the neighbor to the north at 150.
Absolutely.
The conditions that you referenced you would find acceptable, have you put them in writing, or might you put them in writing, so if we wanted to capture them in our resolution, we would be able to get it correct?
Put them in writing to anyone who wants to receive them in writing.
As one member, I would like to see it in writing. I'll defer to my fellow members for other questions.
Any other questions? No? No? Okay, thank you.
Thank you for your time.
Would anybody like to speak in favor of this petition? Would anybody like to speak against the petition?
Good evening, Mr. Chairman, Mrs. DeCilio, Commissioners. My name is Benjamin Proto. I'm an attorney with an office at 2885 Main Street in Stratford. I also live in Stratford, and I represent the property owners at 150 Margarita Lawn, the abutting neighbor that Mr. Rosati had referred to. I'm going to take this a little bit out of order, but I've given you a package of some documents that include, I believe, 6 different documents. The first one is the denial letter from the Zoning Board of Appeals in April 5th, 2007, in which the board denied a variance for the frontage for lot 700 from 60 feet to 50.08 feet. The second exhibit is a copy of the Supreme Court decision in Laurel Beach Association versus the Zoning Board of Appeals of the City of Milford. The next exhibit is the deed to Mr. Alvarez in this property. The next exhibit is the assessor cards for lot 699 and lot 700, both of which are owned by Mr. Alvarez. The next exhibit is the assessor map that Mr. Attorney Rosati gave you, 50.02, but it's just a section of Margarita Lawn, which shows this particular section. You'll notice that they're colored in the, I believe the yellow is the lot in question. The green, 3 green ones are lots that are 50 feet, including Mr. Alvarez's other lot that the house currently sits on. And the last one is what you, Mr. Attorney Rosati gave you, which is the Johnson versus Stratford Zoning Board of Appeals decision from the appellate court. And going a little bit out of order to address Commissioner Young's question regarding the map, I'm not sure it would work in Westport either. Unless your Westport selectmen, prior to the adoption of zoning, had the power of a planning commission. If you read Johnson, Johnson says if they didn't have that power, even if you recorded the map and it was approved, it's not a subdivision map. You still have to come back. So the Johnson case answers your question in regards to why it's not an approved map and an approved subdivision, and why Attorney Rosati is here on behalf of Mr. Alvarez. But most importantly, the reason that this application should be denied, if for no other reason, it's already been denied once. This board cannot approve a variance that it had previously denied unless there is some change in characteristics or circumstances in regards to the lot or the regulation. As Attorney Rosati has more than adequately told you, this lot's existed exactly the same way for well over 100 years. So there's no changes in the characteristic of the land. And there's been no changes to the zoning regulations since April of 2007. Therefore, pursuant to the Laurel Beach decision, which you have a copy of, you cannot approve this variance. It's already been denied. There's no change in circumstance, there's no change in characteristics, and as such, you simply cannot approve that variance at this time. And I would refer you to the Laurel decision on page 1, and it's it's a very short decision, and it's on the second column under the heading of number 1, partway down. It reads, "This case comes clearly within the established law of this state, which prohibits a zoning board of appeals from reversing its previous decision unless the facts and circumstances which actuated the decision are shown to have so changed as to vitiate or material affect the reason which produced and supported it, and no vested rights have intervened. There's been no change in circumstance, no change in characteristic of this lot, of this property, of this area, or of the zoning regulations. You are prohibited by law from granting this variance. And we can end the conversation right there because you simply can't approve it under the law of the state of Connecticut. The other interesting concept here, and I know Attorney Florek is looking forward to this one, is the concept of merger. While we have no merger provision in our regulations, I do believe that this property has in fact been merged with Lot 699. If you go back through the various deeds that Attorney Rosati spent many hours looking at, you'll find that these two lots were at one time independently owned by different entities or different people. And over the course of the years, they changed hands, and in the 1940s, they came in, each lot separately, by separate deed, came into the ownership of the Gladds, Mr. and Mrs. Gladd, who lived there to their deaths. Mr. Gladd in 1994, and Mrs. Gladd a few years later, I believe. What's interesting is the deed into the Mr. and Mrs. Gladds were separate. When Mr. Gladd passed away, Mrs. Gladd transferred the property to her children on a warranty deed through a purchase. And the first time we ever see language appear in that deed, both lots were listed in a singular deed, and if you look at your exhibit, you'll see a highlighted part that says, said premises, both lots, are also known as 98 Margarita Lawn, meaning they intended those two lots to be 98 Margarita Lawn, not Lot 699, Lot 699 and Lot 700 to be Margarita Lawn. If you look at the map that Mr. Rosati provided and that I provided, you'll see that at one time the garage was partially on Lot 700. They've taken part of it down, but at one time Lot 700 was utilized. I believe if you look at the aerial map, you'll see that the driveway crosses the lot line because the house currently sits 9.8 feet off the property line. The driveway is wider than 9.8 feet. Therefore, Lot 700 is being used for Lot 699. So while we have no merger provision within our regulations, use and intent of the property by the owners can bring about a merger of the lots. If, in fact, there has been a merger of the lots, then you would need a subdivision of this lot to make two, and he can't do that because he doesn't have enough land and enough frontage to create two conforming lots. So the merger issue is an issue which I think has to be considered, but again, I'll go back to my first point. You legally can't approve this because they've already denied it. The board's already denied it. Mr. Rosati had also said that this lot was a building lot. If you look at the assessor cards that I've provided, both Lot 699 and Lot 700, you'll see that Lot 699, and I've included some language on the cards which is not on the cards, it's my language. Lot 699 shows a land value of $143,610 of assessed value relating to an appraised value of $205,157. Lot 700 is taxed as vacant land. It is not taxed as a building lot. It is taxed at vacant land with an assessed value of $14,330 and an appraised value of $20,471. Anyone who knows Melinda Fonda, the tax assessor in this town, if she can tax something as a building lot, she's taxing it as a building lot. The Alvarezes and the Gladds have enjoyed paying substantially less taxes on this because they've never irrevocably committed it to a building lot. And that is tremendously important because in the Johnson case, it says if the property has not been irrevocably committed to a use, a pre-existing non-conforming use does not enjoy the hardship that Mr. Rosati talked about by the enactment of the zoning regulations. And that is tremendously important. And I will take you to the Johnson case that we've already discussed. And I think it's important because not only do I think that not only is this case identical to the Johnson case, but it came out of this board when the board properly denied Mrs. Johnson's request. And if you turn to the Johnson case, page 2, under the second column under the headings 3, 4, 5, and those are the head notes that Westlaw puts in, It says merely recording a map of land prior to the advent of zoning regulation does not automatically exempt a non-conforming lot from subsequent regulations. Where land is irrevocably committed to a particular use, however, Section 8-2, which is the section of the statutes which allows the adoption of the regulations, will protect that use from the subsequent enactment of zoning laws. Because undeveloped land has not been irrevocably committed to any particular use, Section 8-2 does not protect the non-conforming undeveloped lot. In this case, the applicable local zoning regulations do not protect the lot. And what it says is that she should have applied for a variance, and if she is entitled to that variance by law, meaning they show a hardship of the property, then they're entitled to the variance. Well, this is a nice rectangular lot, perfect in all sides. It's flat. There's no issues with it. There's no unusual characteristic of this lot which would warrant a hardship that it can't comply. And finally, looking at map 50.02 that Attorney Rosati gave you and the portion of the map that I gave you, you'll notice that this entire street, other than the Alvarez property, all conforms. They all have lots that are in excess of 60 feet on the front. So just to recap, you can't approve this because the law doesn't allow you to, because you've already denied it once and nothing has changed. They're not protected under the pre-existing nonconformity because they've never irrevocably committed this property to a building lot. They've only kept it as vacant land. They've used the land to benefit lot 699, and it simply doesn't fit into the characteristics, and the deed that they received indicates that they've put these lots together. So with that, Mr. Chairman, I would ask the board to deny the application, most notably because you don't have the legal right to grant it, and it doesn't meet the appropriate hardship provisions as the lot has no unusual characteristics. Thank you, sir.
Thank you. Any questions?
I'm a little concerned, Mr. Proto, thank you. So if this board in 1994 or whatever year got a decision wrong for whatever reason, they can never rehear that again? It's in infamy if the person said they didn't have the wherewithal to take an appeal, a bunch of people came out. Is that true?
Yes.
Excuse me.
I'm sorry. I
Proto.
apologize.
The question is, if somebody applied for a variance here and was denied, and that variance should have been granted, your question is, could a subsequent property owner come in and ask for that same variance?
Could they reapply if at some time? Because there was what's with prejudice, without prejudice. I don't know what all that means.
It is not not precisely as hard and fast as Attorney Proto, in my opinion, states. It's a two-pronged test. They have to be seeking the same relief. In this case, they are seeking relief from
frontage. Yeah.
From the frontage, and I actually have that portion of the Laurel Beach. I pulled it up as Attorney Proto was talking. The second inquiry is whether there has been a change of conditions or other considerations that have intervened in that time which materially affect the merits of the application. Mm-hmm. So I believe the first application was in 2007, and now it's 10 years later.
Correct.
In order to reverse a previous application seeking the same relief, the board should find some changed circumstances.
Okay. Thank you.
Any more questions? Oh, Ms. Young.
I have a question for Attorney Rosati in response to some of the questions you raised.
He gets to come back.
Okay, well, I'll put him on notice that I would like to hear his response to some of the issues that you raised. And if he, like me, wished he had the benefit of having a preview of both his documents and yours, you all collectively might join me in wanting to continue this hearing further till we can all see all the information we're all sharing with this board so we can adeptly respond to it. Because I think both attorneys have raised some interesting points that I'm sure each one would like to respond to. And I know I'd like to hear from both of them about what the other guy said. because this Laurel Beach decision, as I heard you describe it, is quite definitive, and maybe I don't need to do any more homework if it is as definitive as you describe, which makes me think that Attorney Rosati, at the minimum, would want to get on the record what material changes he thinks has occurred in 2007 to see if it's even worth our while. Because if it isn't, then it sounds like we should just shut down, deny, and move on.
That's entirely up to the board, but
Attorney Rosati has the right to respond to
He's gonna have rebuttal, right?
any other questions in the testimony from Attorney Proto.
that's why I'm happy to answer any other questions.
Okay, should we call Mr. Rosati up here right now? Or?
There's no further questions.
No.
You could certainly
I
call Attorney Proto
thought
back.
Mr. Hyder could have a question.
Okay,
Thank you.
thank you. Mr. Rosati?
Just in
I was
rebuttal
going to ask
to
when he's done.
Attorney Proto, I believe our regulations say you can come back after a year, and regardless of that, there is a substantial change, and it's a big one. In 2007, 2 applications side by side were required to be before you, and they were both denied together for lot 798, lot 699. It's the opinion now of the town attorney that that second application for lot 69 wasn't needed here tonight because that lot is a pre-existing non-conforming lot that has already been committed to development, and therefore the waivers that were requested back then are no longer needed. Something maybe you think was Ms. Young was not even needed for this. But, so the substantial change is this is a single application for a single waiver. That was a dual application for multiple waivers. And the huge substantial change here, in addition to one application, is our plans show, and again, we'll commit in writing to this, that the encroaching driveway will be eliminated and the garage next door will be eliminated. So there was a huge density issue that was a fact in the record in 2007 that is no longer an issue here. So there's absolutely a substantial change of facts and circumstances, and it doesn't bar us from being here asking for this relief tonight, because it's something completely different from what was presented in 2007. There was also some errors in the map that were corrected from 2007, and the biggest thing maybe is all the evidence I presented, all the facts that I presented tonight were not in the record of what went on with the deeding prior to zoning. If you look at all the exhibits from 2007, it's completely void of the deeding in 1911 prior to zoning from Laurel Beach that showed one dwelling for one lot. This isn't a merger. It's out and out not a merger. A merger is what is shown on other properties on that assessor's map. When the houses were built right on the line, straddled the line, where people intended, made conscious decisions to acquire multiple lots, parcels of lots, and to develop that way. There's no intent here. Just because possibly in error, a few inches of a garage or a driveway were over the line, it's just not the case. It doesn't arise to the intent where there's a merger here. It's completely the opposite of the other merged development in the area. So merger is not an issue here, and there is no merger regulation. In the Johnson case, I believe that was before, if you look at the language in the case, it was before the BZA of Stratford at least 5 times. And ultimately, it came before the board for a variance request that was ultimately granted. So there are plenty of incidents, regardless of what the Laurel Beach case says, that applications have come before this board with substantial change in circumstances and facts. The board has the authority to hear them and act upon them. And I think that rebuts Attorney Proto. He talks awful fast, though. I'm not sure I got everything.
Oh, question, Ms. Young.
If I may ask Attorney Florek a couple of questions. We heard Attorney Rosati discuss, I guess, the one-year policy that the town of Stratford has, don't bring back the same application within a calendar year, versus the Laurel Beach case that says never bring back the same case twice. Which is controlling, in your opinion?
I mean, I don't know that right offhand. I don't know if the regulation would control or the case law would control.
If this is a Supreme Court case of Connecticut, I'm thinking that maybe that would be controlling.
Laurel Beach was an appellate level decision from 2001. I would rather tell you I don't know than give you the wrong answer tonight. So I just don't know off cuff.
But if we were to continue this hearing, you could get back to us.
I could do that if you so request.
And do you agree that this question that Laurel Beach, I guess, raised of is there been a substantial change in the facts in comparison to the original application versus the one we're looking at tonight, that's a finding of fact made by this board?
Absolutely. What I was discussing with Mr. DeCilio in regards to whether a subsequent application is substantially the same and seeking the same relief, and whether there has been material changes in the application, that is the legal rule. The factual determination is for you guys to make, to determine whether there has been material changes in the circumstances in the intervening years. And I might add, if you do continue this hearing, that you should read the Laurel Beach case, because I think it had to do with a vacant lot on a house that they sought a variance for twice in 10 years, which is a factual circumstance similar to the current application.
I know I would benefit from reading it, so thank you for that. Last question for you, if I may. We've heard discussion of merger. The opposing attorney suggested that there's been merger by intent or by other actions, such as the driveway straddling the property boundaries and other actions. In your opinion, would it benefit this board for us to seek your legal opinion about when does merger happen through action by a property owner, whether it be by how they've conveyed the land, how they've described it, how they've treated it, how they've improved it? I feel I would benefit from that, but I don't want to give you a homework assignment if you don't think it'll benefit me.
Well, I mean, Laurel Beach also dealt with the issue of merger. I mean, it dealt with two similar mirror image lots that I can't remember if it was the people who opposed it said the lot had merged, but the court noted, and again, I'll read it verbatim, generally merger is found where the adjacent tracts have been used as a single property over a long period of time. That's a very broad general statement of the law, but that factual determination has to be made by you folks. And my understanding is there's no silver bullet as to a fact that would say without a doubt that merger has occurred or not. I would, as you guys should look at a totality of the circumstances in making that determination.
Thank you.
You're welcome.
Okay, any more questions? No? Thank you, Mr.
Can I just inquire about closing the public hearing? You don't have to vote tonight if you have legal questions of counsel, but from my perspective, I don't see any need to keep the public hearing open. And I just as soon have it closed on the record presented tonight.
Well, I'm quite sure some other people would like to speak for or against the petition, so I will keep it open. Thank you.
Does that mean I still have a right to rebut? Because I didn't think there was,
Yes.
okay.
Would anybody else like to speak against this petition? Except you. Okay.
Laura, if the hearing is kept open, will the next hearing occur within your 65 days? Do you need an extension agreement from the petitioner?
I'd have to check. I think this is, well, we do not need an extension. No.
Okay. Hearing nobody speaking against petition, will anybody speak for the petition? Okay, hearing none, I need a motion to close. Mr. DeCilio, Mrs. Young?
I'm not supporting that motion, no.
Oh, I thought you were.
I'm waiting for the discussion after you have a second to the motion.
Okay. Do I have a second? I guess not. Okay. Do we have any discussion?
I just have a question. What is your purpose for wanting to extend this?
I appreciate all the effort that Attorney Rosati put into gathering the information that he gave a single copy to of each item to this evening, that I'd like the benefit of reading through it, as I've heard two very intelligent attorneys tell me two opposite things, and I'd like to weigh the evidence before going into work sessions, because once we close the hearing, we don't have the benefit of asking more questions of the attorneys who've appeared tonight, which is why I want to preserve the ability to ask more questions after I've had the benefit of reading through the information.
Are you going to require any kind of a response from our legal staff here?
It's hard to know without having reviewed the information. It may be very self-explanatory. The case law that we've been provided may answer my questions, and I was trying to get a hint out of Mr. Florek if he thought it would benefit me to ask for a memorandum about under what circumstances this merger happened. I think he answered that by saying it's not black and white. That's again why I think I personally would benefit from seeing the evidence that both attorneys have provided us with us tonight, and since the first motion failed to get a second, I will make a different motion if it's timely to do so, to keep this hearing open until the next meeting, and I hope that I can get a second to my motion to give us all the benefit of the time to review this information.
Ms. Young, would you like to make a motion to table this petition?
I think I just did.
Oh, I didn't hear it. Okay, do we have a motion to table? Do we have a second?
I'll second the motion.
Second. All in favor? Aye.
Do we have to pick a date?
Any guess? Nope. Carries. All right, thank you very much.
Mr. Hibansky, to what date are we continuing this?
Let me look it up on the calendar. We will be continuing this application to May 2nd at 7 o'clock.
Thank you.
Okay, thank you. Thank you very much. Okay, right now I'm going to close the public hearing. Do we have a motion to close? Mr. Hoydick, Mr. Tavares? Okay, all those in favor? Aye. Okay, who would like to take, I just lost my paperwork. 446 Riverdale Drive. Take that, Mr. Hoydick.
I'll make a motion to take it off the table.
And a second by Mr. Greger. Okay, all those in favor? Go ahead.
All right, I'd like to make a motion to approve 446 Riverdale. Basically, from the response from the applicant, even though it's kind of a thin hardship, but they're saying that by having the attached garage and allowing entrance and exit through the garage for their elderly parents, it would be enough for me to make a motion to approve this application.
Okay, we have a motion to approve. Do I have a second?
I just have one question.
One more
Mr. Chairman.
question.
I'd like to, pardon?
Go ahead.
Just one question. Well, the applicant stipulated that they were going to use the driveway that's going to be perpendicular to Riverdale Drive. Should that be committed in writing just to make sure that it's what the applicant advised.
We'll put that in as stipulation.
So, condition to remove the horseshoe driveway.
Yeah,
Okay.
right.
Okay, now
I'll
we
add
got
that into my motion.
motion by Mr. Hoyt.
Well,
second by Mr.
I'd
Grego.
like to speak first. I'm in favor of it also, but on the survey map here, none of his proposed measurements are put in. I'd approve it and be in favor of it if he sticks to what all the measurements the permit requires.
And I think Commissioner Gregg is asking that the zone development table be filled out and completed.
Right.
Okay. Okay, all those in favor with the two stipulations, say aye.
Aye.
Aye. Any nays? Oh, yeah, that's right, sorry. Okay, passes. Okay, and who would like to take?
5-0.
5-0, yeah. 466 Riverdale Avenue, would like to take that off the table?
I'll take that off the table.
Mr. DeCilio, do I have a second? Mr. Tavares? Okay, any discussion?
Well, this is basically identical to the previous next-door neighbor's petition in granting a waiver on the coverage. The only other issue is the front porch, which I have no concern with, but that's the only difference in this particular application.
Okay, so would you like to make a motion to?
We're still discussing, I think. If there's no other discussion, I'll make a motion to approve 466 Riverdale Drive.
Okay, do I have a second?
As presented. Second.
Mr. Tavares? Okay. All those in favor? Aye. 5-0. Yep. Okay. Would like to take petition number 3 off the table. Miss, okay, Miss Young, and do we have a second? Mr. Tavares?
Just have one question about.
Oh,
Mr. DeCilio, you said that you had some concerns. Now, are you saying that you have concerns with the configuration of the structure? Were there any safety issues there, or was it just, personal?
I think we already just approved that, so.
Oh, all right.
But I had no concerns. I just brought it up as a point of differential between the two applications. But there were no
okay.
concerns.
Everybody happy? Ms. Young, would you take number 3 off the table again?
Motion to take number 3, 1745 Cut Spring Road off the table.
Okay, do I have a second? Mr. Hoyt. Okay, any discussion? No discussion? That's
I
amazing.
think I said everything I
Okay.
meant during the hearing.
Okay,
I just
do I have a
felt that- I just
motion
felt
to
that
approve?
This application was, it was just based on the notes of Mr. Hibansky. He cited the rationale does not appear to qualify, and there is a solution of, I know there's an expense associated with it, but the roof can be modified, and this can be conforming. And it just, when a builder makes an error and then comes before, and then builds the whole house, and then comes before this board, it just always rubbed me a little wrong. There's a, and I'm not sure what in Stratford the regulations are, but, normally, I've represented a lot of builders in my career. You pour a foundation, you get an as-built, you go in, you supply your as-built, then you get, your frame, and you go through the motion. This was just built, and then you're like, well, now we're here
Right.
considering relief.
Well,
So it's just my point, my 2 cents.
my point is they inherited it. They didn't build the house.
Pardon me?
These people inherited it.
I understand
They
the
didn't build the
transition, the
house.
finance, the repossession,
Yeah.
foreclosure and all that, Anyway, my 2
Okay.
cents.
Any more discussion?
I would just add to that, I wish I could have gotten on the record information about whether or not building code required this. I heard a lot of it might, we think it does, we're not sure. That would have helped me better be able to support this if I knew there were some building code requirement that required that roof to be on top of that porch. And I think it must have, if it was so obvious that it was necessary, I bet it would have been in the application, and it wasn't, which gives me rise to think it's not a building code requirement, but we'll never know because it wasn't put on the record, which might give me reason to make a motion to deny without prejudice, giving an applicant the opportunity to come back with more information to make a more compelling application. And if topography was on their survey, a topographic hardship might make more sense. But I'm still in discussion mode, waiting to see if others have more to say.
Any more discussion? Hearing none, would somebody like to make a motion? Deny? You made a motion to deny
I
without
give a
prejudice.
preview of a motion, now I'll actually make it.
Okay,
Motion
right.
to deny without prejudice, citing insufficient information to support, which Mr. Urbanski helped me, will allow an applicant to return quickly, that they don't have to wait a year to supply what at least would make this member more supportive if I knew there was a building code requirement necessitating that roof, and if I saw topography on the survey justifying a topographic hardship.
Correct. If you deny without prejudice, they are able to return. I don't believe that there is something in the building code that requires it. I've been in construction my whole life. I don't ever recall ever hearing that. So I can't give you a 100% answer, but
Well, I had asked it on the record,
No.
neither could the applicant, so I'm allowing them that opportunity to tell us all something that maybe they couldn't tell us tonight. I may not get a second to my motion, but that's my motion.
I will second the motion.
We have a motion and a second. All those in favor?
Aye.
Aye. 5-0. Okay, thank you very much, people. And what else do we have? Any other business?
Yep.
All right, you're done.
Mr. Chairman, may I make a motion to approve the minutes of the February 7th organizational meeting?
Okay, we have a motion. Do we have a second? Mr. Vars, all those in favor?
Aye.
Aye,
Not voting, I wasn't there.
right.
Okay. Just an
You want it?
abstention.
Yeah, just 5-0. Okay. Okay, we have a motion for the February 7th meeting.
I'm sorry, let me amend my motion, now that we voted, that for the organizational meeting and the hearing and administrative session. Thank you. Correction.
Okay, anything else?
Yep. We have a CAM application for 107 West Beach Drive.
Okay, seems like.
Yeah.
You wanna give us- Okay, I need a motion to take this off the table for CAM review.
Yep. CAM site.
Campsite application. Mr. Hoydick. We have a second. Mr. DeCilio. All those in favor? Aye. Any discussion?
Yeah, why are we hearing this? We approve coastal area management applications in ZBA here?
We can.
There you go.
Sure. Well, I'll just give you a quick overview. And I'll just be kind of repeating what was in my staff comments. The home 107 West Beach Drive previously presided on the sand on the beach at the condominium complex. In 2002, or I should say, the home was destroyed in a coastal storm. In 2012, the applicant applied to the BZA to reconstruct the single-family dwelling on the beach, which was actually granted. The applicant has now come back seeking to reconstruct the house. However, they are not proposing to reconstruct on the beach, but set back across the driveway by the tennis courts. I know that has been a recommendation by the Department of Energy and Environmental Protection for this particular condominium complex. They had asked that any rebuilds be built where there is available land across the street or across the driveway by the tennis courts, and the applicant is doing that. The coastal resources that are in this area, according to our coastal resources map, are beaches and dunes, and I'll just quickly read it to you because I don't remember exactly what they are. Moderately sloping shores composed of waterworks sand, gravel, or cobble deposits, and when present, wind, water, and coastal bluff escarpments, or dunes or vegetation. The map designated includes all areas of sandy beach fill, dunes and sand flats positioned landward and elevated above the beach, support coastal grasslands dominated by beach grass. It is difficult to be certain, but the newly proposed, actually, well, this is my own assessment here. It's difficult to be certain, but the newly proposed location appears to be just outside of this beaches and dunes designation. However, it was close enough to at least mention it here in my staff comments.
I have a question for Jay. Didn't this occur a couple of years ago? Didn't zoning approve this a couple of years ago?
The Board of Zoning Appeals did.
Yeah.
Yes, the Board of Zoning Appeals did in 2012.
It wasn't heard in zoning also? Wasn't there an issue with the zoning board on this one, or no?
I don't believe so.
No?
I think you're thinking of
Or there was one that was similar, right?
Gorlow. I can't remember the name of the property. I just remember the applicant.
Okay.
Donald
But this
Gorlow.
was a couple of years ago, though, right?
Last year.
Last year, right, okay.
Just to make sure I understand what we're doing, we didn't have a public hearing. This is a, if you will, a work session administrative issue where a variance was previously granted. They're asking for it to be modified to shift the house, and that's why we're talking about it now?
Nope, there are no variances. Any board in the town of Stratford can hear a CAM application. So just based on the timing of when the applicant applied, based on the 35-day review period required by the state, the Board of Zoning Appeals just happened to be the first board that they could apply to. So it could have gone to the Zoning Commission or the Board of Zoning Appeals for an administrative review.
Why didn't we give it to the zoning commission or the planning commission, who might be meeting next week or the week after?
Because this actually happened just to be the first board that met within their 35, once they fulfilled their 35-day review period. They did the calculation when they submitted their application.
Okay, I guess I'm not used to this, so I'm just trying to wrap my head around it. So in your opinion, any board could do the CAM review, and we're the first one in line, so why not us?
Correct.
I understand better. I'm not sure I think we are the best suited board for it, but I better understand. Thank you.
I have a question. So this is just a discussion just to, before it gets to the point where they put in a formal application and people can speak for or against this. Is that pretty much what this is?
Can you repeat that one more time?
This is just a discussion on before they formally put in an application so that folks can speak for or against.
No, the coastal site plan reviews do not go for a public hearing unless specifically requested by a board.
Thank you.
And I'm sorry, your staff report identifies, in your opinion, when you compare the prior layout, this is an improvement from an environmental perspective as it shifted further away from the coastal resources, if I read that correctly?
A significant improvement.
John Goucher from the DEP talks about concerns he had in January, and then there's a subsequent February email where he says, for the most part, all of his concerns have been addressed, but points out the need for breakaway walls to be shown on the plans consistent with the DEP requirements. Can we assume that whatever John Goucher asked for, you will make it happen?
Yes.
Thank
I
you.
can include any recommendations made by Mr. Goucher be included as a condition of approval.
That would make me feel better. I'm still not feeling good about BZA being the board that this is in front of, but maybe we talk about that at some later point in the agenda. Motion to approve if it's timely
We
to
have a
make one,
motion to approve. Do I have a second?
with the condition that Mr. Hibansky
With the
fulfilled John
stipulations
Goucher's
in there.
comments.
Motion by Ms. Young, second by Mr. DeCilio. All in favor?
Aye.
That was 5-0.
Yep. Okay, members' concerns and comments.
As a follow-up to our last conversation, and forgive me, I mean no disrespect to my fellow members, but I typically think of the planning commission or the zoning commission as being more, just because of the frequency of the applications that come in front of them, more familiar with what are the coastal area management policies, what does a good one look like in comparison to a bad one. So I'm not a fan of first in line gets it policy, and if this has been going on for decades and I'm the only one who didn't know it, forgive my ignorance, but if we're starting something new, I'm not a fan.
We've heard multiple CAM applications for the Board of Zoning Appeals. I think, and I used to actually not do staff comments for them. I would just use Deep's comments as the staff comments, and I believe one of the commissioners asked that I start doing them.
That was me.
so that we're at least considering what coastal resources are potentially being impacted. So
Associated with a pending application for a variance. I've never seen a standalone. That's why I'm having a problem absorbing what we're doing
yeah, I'm
here.
not too sure what Gary's the prior planning and zoning administrator's position was on it. It sounds like he didn't do that. Where I came from, at the city of Bridgeport, that's what we used to do, whatever, in order to make sure that we weren't holding up any applications unnecessarily. We made that possible for them. I would, if the Board of Zoning Appeals does not prefer that, I want to make everyone happy.
Thank you for making us happy. I might suggest that if you go back, if you're able, or if Gary's still accessible, ask him, where did he usually send them? When I served on the Planning Commission, I know we got a lot of them, but I know there's some other members here who've served on all of the boards, and maybe they know better than I who was the beneficiary of the CAM application. I was under the impression ZBA, BZA didn't get them unless it was attached to a variance application, but I've learned a lot tonight. Like, I've learned about merger and the Johnson case, so I'm learning as I go here. That's one member's concern. It may not be the majority.
Any other concerns? Nope. Okay.
There's nothing else on the agenda.
Okay, can we have a motion to adjourn?
Motion to adjourn?
Mr. Vars, do we have a second? Mr. Hoyt? Thank you very much, guys.
All in favor? Aye.
If anybody wants to stay, they're welcome.
Sounds like Westport's getting it wrong. I got to read the Johnson case.